I'm going to talk today about bail. The law relating to bail is set down in a number of pieces of legislation, and these include the Bail Act of 1976, the Police and Criminal Evidence Act of 1984, the Criminal Justice and Public Order Act of 1994, and the Legal Aid and Sentencing of Offenders Act 2012. It's also covered in the Criminal Justice Act 2003 and in the Criminal Procedure Rules and elsewhere. But it's consolidated in a number of different pieces of legislation. And the first thing to say is that under Section 4 of the Bail Act 1976, there is a presumption in favour of bail. That presumption applies to all offences with the exception of the most serious, for example, murder, manslaughter, attempted murder, and in Northern Ireland or in Scotland, rape. There is a presumption in favour of bail unless those offences apply, in which case there is a presumption against bail. Now, bail can be divided into two parts. There is bail related to the police station and bail related to the courts. When I say courts, I'm going to talk primarily about the Magistrates' Court because that's where most matters will be dealt with, but it applies equally for the Crown Court with a few exceptions. So at the police station, when an individual is arrested, following an investigation, following interview under caution, the police may either wish to charge the individual and bail them to court, or may wish to release the individual on bail for them to return to the police station. And there are rules relating to the amount of time that this can be done, and normally it's limited to 28 days. When the custody sergeant is considering release on bail, it will either be without conditions or with conditions. If the individual is to be bailed to return back to the police station with bail conditions, the law concerning that is governed under Section 37 of the Police and Criminal Evidence Act 1984. If the individual has been charged and is to be bailed to attend court, that is under Section 47 of the Police and Criminal Evidence Act 1984. Now, when the individual is given a bail date, it means they have to go to court, they have to physically attend court in person. If they do not, then it may be that they commit an offence. The offence may be under Section 6.1 or under Section 6.2 of the Bail Act 1976. Both Section 6.1 and Section 6.2 can be dealt with by a maximum 3 months custody in the Magistrates' Court and or a level 5 fine. But there is a difference between the two, and it's this. Under Section 6.1, the individual is charged with failing to answer their bail without reasonable excuse. Under Section 6.2, the individual is charged having had a reasonable excuse but not having surrendered themselves at the earliest opportunity. So, for example, if they were ill on the date, if they can prove that by way, for example, of a doctor's note or a medical note or something like that, then they might be able to prove that they had reasonable excuse. But under Section 2, the offence is not failing to surrender because they had a reasonable excuse, it's failing to surrender as soon as possible thereafter. So, under bail, there is a presumption in favour of bail, and an individual may expect under Section 4 of the Bail Act 1976 to be given bail unless there are substantial grounds to believe, reasonable grounds to believe, that either they will abscond, that means that they would fail to attend court, or that if they were granted bail they would commit offences, or that if granted bail they would interfere with a witness or otherwise interfere with the procedure. And there are other matters that the Magistrates' Court may wish to take into consideration, such as, for example, the seriousness of the offence, the likely sentence, potentially, if convicted. So The legislation is set out in the Bail Act 1976, in the Police and Criminal Evidence Act 1984, and under the Criminal Procedure Rules. There is one case that I wish to mention, and that's of Richards, DPP against Richards. The circumstances of this were that Mr. Richards was bailed by police to attend court. He went to the court, he gave his name in at the court desk, waited a while, and then left. The matter was called on, he wasn't present, and a bench warrant was issued for his arrest. He was eventually arrested and brought back before the court, and he tried to argue that because he had given his name in at the magistrate's court desk, he had surrendered to bail. The court disagreed. It said that simply handing your name in at court was not sufficient to have surrendered to bail. You had to remain at the court until your matter was addressed. So under the case of Richards, it's not sufficient simply to go to court and to give in your name. You have to remain at court until your matter is called on.